And welcome to the latest of our SQE webinars. Today we're going to look at the work that we are doing to update our evaluation of the risks and benefits of the SQE, particularly from a point of view of equality, diversity and inclusion. So moving to the first slide, I'd like to remind you what we have already done. So back in 2016, to accompany the second consultation that we went out with proposing the introduction of the SQE, we published an EDI risk assessment then. That set out an evaluation of the risks and benefits of the proposal as we saw it at that stage. And we also asked the Bridge Group, which is an independent organisation which looks at and promotes equality of opportunity, inclusion and so on, to look at the EDI benefits and risks around SQE itself, and the Bridge Group report was published in 2017. So the Bridge Group looked at the work and published their own report alongside our risk assessment. So moving to the next slide, what are we doing now to take this work forward? Well, we've gone back to the Bridge Group and we have asked the Bridge Group to update their 2017 report, and that will be published later this year. At the same time, we're updating our EDI risk assessment in the light of the work that we have done since 2016 and 2017 to develop SQE. And what we want now is your views on our updated draft risk assessment. So we're doing targeted engagement at the moment, and we're also doing an online survey, and at the end of this webinar there will be details of how to get access to the seminar, to the survey, and I do hope that you all participate. So moving to slide 3, what do we think the key risks and benefits might be? Well, back in 2016, we identified the key areas to look at as being the cost of the training and the qualification, fairness and consistent standards, and access to qualification as a solicitor. And what I'd like to do now is talk through each of those points in turn so that we can explore what we know now that we didn't know then, and any additional risks or benefits that we have identified since 2016 and 2017. Moving on to the next slide, this sets out what we know now about cost. So in 2016, we had not yet procured a provider to deliver the SQE, and we hadn't done work around possible costing of the SQE model. We've now done that work with Kaplan, our assessment organisation, and we have published the indicative costs for the SQE assessments. They're set out on the slides there. We put them as between £3,000 and £4,500 in total for SQE1 and SQE2, and you can see there the breakdown of those costs. Now, the exact spot cost, spot fee for the assessment will depend on the exact assessment design, and we still have to make decisions around that, but that gives you at least an indication of the likely size of the fee for the SQE assessment. In relation to the training market, work is well underway. Lots of training providers are developing options for training. We hope and expect that there will be a range of different options open to candidates and a range of different price points. Some providers are looking to develop very SQE focused training. Others are looking to add wider training that goes beyond SQE, perhaps in relation to legal tech or project management or business awareness. So lots of different models that are being developed there. But what we know from the still relatively limited information publicly available is that some options look as though they should be cheaper than the current cost of qualifying as a solicitor. So work's still ongoing there, and the training market still developing, but importantly, it seems to us that what we hope to see in terms of a range of provision and choice for candidates is coming through. Different providers are providing different models in relation to training. Moving on to the next slide, in relation to mitigations around costs, well, first of all, importantly, there are contractual mechanisms to help us control the cost of the SQE assessment itself. The SQE fees need to be agreed with us. And also importantly, we will provide resources to help candidates understand some of the options and some of the training that's available to them. So there will be lots of different alternatives, and we will provide options so that candidates can understand some of the types of training that are available. We do have a list of providers already on our website who've indicated that they are interested in providing SQE training, and I think at the last count there were about 33 providers listed on included in that list. So that's already looking like a wide amount of choice. And the information will also be available through our Facebook page, Career in Law, which is aimed very much at aspiring solicitors, so that information will also be available there. So we will make sure that we provide information to candidates so that's readily accessible and they understand the choices that they have. Moving on to slide 6, we will also provide information to candidates about the candidate performance by provider, so they can look at pass rates by the different providers and make an evaluation of how effective the provider's training is in terms of helping their decisions about where and how to train. Now, there'll be lots of other things that candidates will want to look at too. Some providers will have more face-to-face training, others will have more online training, some will have models which suit a learn while you earn model where people can combine training with work experience, and so there'll be lots of things for people to take into account when they decide their training. But this will be part of the information which will be available to help candidates choose their provider, their training provider. And we continue to discuss funding and access to loans with government. All the access to the student loan schemes that are available at the moment, if you do a law degree or a postgraduate law degree, will be available if you choose to train through that route. What we're exploring specifically with government is the extent to which there might be access to loan funding to pay for the SQE, the separate SQE assessment fees. One good thing which is noted on the slide there is that people can, coming through the apprenticeship route, can use the apprenticeship funding to pay for both the cost of training and the cost of assessment, and that there is also an apprenticeship route for people who are graduates. So people who come out of university with a law degree or a non-law degree can use the apprenticeship route to take them through qualifying work experience and SQE 1 and 2 assessment, and the apprenticeship levy funding can be used to pay for all of those costs, including the SQE assessment costs. So that is useful to bear in mind. So that's the points that I wanted to highlight in relation to cost. Moving on to the next area, which is fairness and standards. One of the critical things for us in developing SQE is that it must be fair to all candidates. One of the great advantages, we believe, of SQE is that a centralised assessment means that everyone is fairly and consistently being assessed through the same tests. So, moving on to slide 7. What has changed since our last EDI risk assessment? Well, clearly what we have now done is we have completed our pilots of SQE1 and SQE2. We've published the findings in relation to the SQE1 pilot, and we're partway through analysing and evaluating the findings from the SQE2 pilot, and I'll say more about that in a moment. What we know from the SQE1 pilot is that white candidates generally performed better than Black, Asian and minority ethnic candidates. And that was true both in the what we call the FLK, the Functioning Legal Knowledge Assessment, the assessments that are designed to test candidates' legal knowledge, but also it was true in relation to the Small Skills Assessment that we also included within SQE1. So moving on to the next slide, what we found through that pilot was that the design of the SQE1 skills assessment was not sufficiently robust. The core finding in relation to that skills assessment was that we could not be sufficiently sure through the design of the assessment that we could be confident about the accuracy and reliability of the pass-fail decisions around the boundary. So that was concerning. What I said, and then the slide also makes the point I made a moment ago, that the SQE2 final pilot findings and the final design will be available in the summer. But moving back to SQE1 in slide 9, because of the concerns in relation to the SQE1 skills assessment, we are looking at that design again. And many of you will know that we have been talking to law firms and training providers really since back in sort of August, September 2019 about how we should take that forward. Do we really need a skills assessment as part of SQE1? Can we rely on SQE2 skills? If we do need a skills assessment in SQE1, how can we make sure that that is robust and fair to all candidates? So that's a piece of work which is still underway. The slide goes on to say to set out some of the measures that we will be putting in place to make sure that the skills that the SQE assessment is a fair assessment to all candidates. It's absolutely critical that the assessment should treat all candidates evenly, fairly, consistently, so that everybody knows that they have been fairly assessed once against the other, and that it's a standardized assessment, and that everybody has been treated fairly. So we will be putting in place protections and processes and safeguards to achieve that. All the SQE questions will be reviewed for cultural bias. So to make sure that there is no implicit cultural knowledge or understanding which is assumed in the questions, to make sure they're fair to all candidates. We will also be wanting to recruit and train a diverse pool of question writers and assessors, and I think this is one of the most critical ways to make sure that the assessment is fair to everybody. We will be recruiting question writers and assessors as we get closer to the start of the SQE, and if anybody is interested in being recruited as a question writer or an assessor, please let us know. We're working closely with the special interest groups within the profession, and we would very much welcome applications from a wide range of candidates, making sure that we can recruit a diverse set of question writers and assessors. All our question writers and assessors must be qualified solicitors, and as I say, beyond that, we want to make sure that the question writers and assessors reflect properly the diverse makeup of the profession. And finally, we will have mechanisms in place to monitor assessment decisions. We can do that because of the assessment methodology that we're using through looking very, very closely at individual question performance. We can also do it through reviewing and monitoring the decisions of individual assessors, and we can, through something called that Kaplan uses called Crucible, which is an online mechanism which enables you to be able to monitor and see assessment decisions as they are made. So lots of work there, lots of work to make sure that all the question writers, all the assessors properly understand the objective standards that we require for admission as a solicitor, and that they understand how to apply that standard objectively to all the candidates they are assessing. And Kaplan has already appointed external expertise to advise on these issues, to make sure that we have access to proper advice, to make sure that people are trained properly, our training is fit for purpose, that unconscious bias is picked up. So a lot of work to go on there to make sure that the assessment is and is demonstrably fair to everybody who attempts it. Moving on to slide 10, likewise at our end, we at the SRA have appointed our own SQE independent reviewer who will be monitoring all of those issues. We will monitor performance by protected characteristics. We'll be looking closely at that and wanting to keep that under review over time as the assessment goes live. One of the things that we hope to be able to pick up through this is where we can see pockets of good practice, so where we can see particular candidates from particular trainers coming through who are doing well across all the protected characteristics. And that may enable us to provide a really useful and helpful mechanism to make sure that we can share and disseminate good practice across the sector. And the final point there on reasonable adjustments, as you would absolutely expect, we will require and expect candidates who need reasonable adjustments to be made to have those adjustments made. It's a legal requirement and it's also a contractual requirement, and all of those mechanisms will be put in place. Again, it's something we will be monitoring, and I should add that Kaplan has many years of experience of doing this through the Qualified Lawyers Transfer Scheme, so it's not new to them, and of course, as many of you listening will be aware, it's not new to the sector. Making reasonable adjustments is quite rightly and properly routine in our sector, and it will be routine in a routine process as part of the SQE. So moving on then to the next issue that we wanted to explore. As we said, as I said earlier on, we are still in the process of exploring the and making final decisions about the final design of the SQE2 assessment. And one of the things that we're looking at is whether the assessment design should be that everybody takes the same skills in the same practice areas, or whether we allow an element of choice so that candidates can choose from our list of 5 contexts, 2 of those contexts in which to have their skills assessed. And just as a reminder, those 5 contexts are the reserved activities, civil litigation, criminal litigation, probate and the administration of estates, and property law and practice, with the addition of business law and practice, which is such an important and widespread area of practice within the profession. So those are the practice areas. And the question for us is, when you're having your skills assessed, should you be able to choose to have them assessed in 2 out of those 5 contexts, or should we require everybody to be have their skills assessed across all of the reserved activities, so that they can demonstrate that they are safe to practice in all the areas in which they are being licensed to practice? It's a tricky issue. It's a change, if you like, to existing custom and practice, where at the moment we don't require, through the period of recognised training, that people develop competencies that they can demonstrate across all the reserved activities in order to be signed off at point of admission. So let's just think and consider some of the risks around each of those options. And I think it's fair to say that both the uniform model and the optional model carries potential risks. And one of the things we need to do is really evaluate what is the best way forward through all of that. So the first point about the uniform model is the first bullet, and I think this is really a very important benefit actually of the uniform model. The uniform model does mean that it's a fair assessment of all the candidates taking the same test. It does mean, consistently with our overarching objective for SQE, that we can demonstrate that all the candidates who attempt SQE2 have taken the same consistent assessment and been fairly assessed against the same demonstrable standards. So that is a very important factor, fair assessment for all candidates, and also best alignment in relation to the license to practice. So it means that that all candidates have their skills assessed across all the reserved activities, and also in relation to business law and practice. But given that not many law firms can offer qualifying work experience across all the reserved activities, we recognise that this may drive a need for additional classroom training. So what it may mean is that candidates can get a lot of helpful experience through their work experience that helps them develop their skills, certainly in some contexts, but they may need additional classroom training to enable them to be able to extend their application of those skills into practice areas which they don't have work experience in. So, for example, somebody may in a firm have lots of experience in relation to interviewing clients in crime, in civil litigation, but they may not have experience of probate. So they may wish to top up their work experience through classroom training, which enables them to take those generic skills, if you like, or those skills that they have learnt through to apply in the context of civil and criminal litigation, and think about how to apply them in the context of probate law and practice, or probate and the administration of estates. We recognise too that the current practice in our profession is that people choose the firm in which they gain their work experience in the light of their aspiration about the sort of legal practice that they want to go into. So somebody may choose to go into a firm that specialises predominantly in business practice because that's where they want to end up working. Somebody conversely might feel very strongly they want to work with individual consumers, and so they go and work in those sorts of organisations. Now, a uniform model does not reflect the particular career aspirations of individuals and the work experience that might be associated with those career aspirations. So that's something for us to bear in mind. We think that this model, the uniform model, is probably carries with it the least assessment cost, the lowest assessment cost, but the need for additional classroom training may mean that there is additional training cost, and of course that additional training cost may impact on candidates from lower socioeconomic groups in particular. So if we move on to have a look at the optional model, again, this really what we're going to see now is the flip side, the reverse face of the coin to what we've just talked through. There is a risk that this may be less fair to all candidates because different groups may take different assessments. We will not be able to say everybody's taken the same test and therefore everybody has been assessed fairly against the same standards. We will and would put in place quality assurance mechanisms to try and make sure that the different tests were, as far as we could make them, of equal level of difficulty. But that's quite hard to get exactly right. So there would be a risk around that in relation to candidates potentially being assessed through different tests where we might not be sure, and certainly would not be as sure as we would be on the uniform model, that everybody was being assessed fairly and consistently. But of course, conversely, it does help candidates use their work experience to focus on the skills that they need and where they would be assessed through SQE2. Some protected groups may be disproportionately represented in some specialisms, and again that may be relevant to the first risk there on the bullet point, that if there were different groups taking different assessments, and actually that we had different, perhaps different patterns of ethnicity or gender associated with particular specialisms, that may mean that it may create more of a risk in relation to being able to demonstrate that we were fair to all candidates, because it may be very different comparisons between candidates who were assessed in different areas. And that may be particularly the case if, moving on to the next slide, if the failure rate was variable according to the specialisms. If protected groups were disproportionately represented in some of those specialisms, that may create the perception of unfairness, and it may not promote diversity in the profession. So there are some risks around the optional model in terms of fairness, in terms of demonstrable fairness, and being able to demonstrate fairness across different specialisms when potentially different cohorts of candidates are taking a different test. And again, the assessment cost is likely to be greater for this model. So the assessment cost of the optional model, we think, would be more than the uniform model, but the training cost might be lower because people would be able to use more of their qualifying work experience to prepare for this. So again, that assessment cost may disproportionately affect candidates from lower socioeconomic groups. So that's one of the issues that we are currently very much wrapped up in and currently exploring, and we'll be very, very pleased to have your input and views on in relation to which of those you think where the balance of risk lies in relation to each of those options. Let's move on now to the next slide, slide 15, which looks at the emerging findings from SQE2. Now, this is still, as I say, we haven't finished our work on SQE2, so this is still at a state of emerging findings. But Kaplan have looked at candidate performance by predicted characteristics, and it's fair to remind ourselves always that candidate numbers are relatively small in all our pilots. Just to remind you, on the SQE2 pilot, we had a total of 167 candidates who took it. That means when you divide them up into different groups by the different protected characteristics, you end up sometimes with very, very small numbers in some groups. And that means that, you know, slightly different individual performances can make very, very big different statistical changes when you have such small groups. Remember that characteristics were self-declared, and there are always lots of different factors to take into account when which can determine individual performances. You know, somebody is always either a man or a woman, or from different ethnicity, and has a different academic background, and all of those, the combination of all of that goes into finding into the ultimate performance on the assessment. So lots of things to pick up there. Moving then on to slide 16. What Kaplan have undertaken is something called a univariate analysis, which looks at performance by those different candidate variables, so by ethnicity, by gender, by prior academic attainment, by disability, and so on. And then it also looks at multivariate analysis, which seeks to identify which of those is the best true predictor. Can you work out which of those different, often overlapping elements is the best predictor of performance in the assessment? Now, both of those analyses need to be viewed with significant caution. First of all, because of the small numbers, as I've already said, but second, in relation to individual candidate variables, because those variables overlap and it's not clear whether one is the true cause or another, and in relation to multivariate analyses, because again you're trying to tease out which is likely to be the ultimate predictor, but it's never going to be absolutely conclusive. So with all of those words of warning and caution, let's move forward to have a look at what the emerging findings seem to be showing us. So in slide 17, the univariate analysis showed that there was no significant performance overall between men and women, but there was a significant performance between white and BAME candidates when we look at those on a binary ethnic divide. We went back and had a look, let's have a look at slide 18, we had a look to try and again work out through the multivariate analysis what the main predictor was of those of that finding, and what we saw was that when we looked at performance in the multiple choice test, which was we had included for the purpose of the pilot in the SQE2 pilot, just to get some sense of the greater insight, if you like, into the makeup of the pilot group, we found that actually the largest predictor of performance was actually candidates' ability to perform well on the multiple choice test. So the ethnicity disappeared once you took into account performance on the multiple choice test. And of course, just to say that our overall plan for SQE is that candidates will only be able to progress to SQE2 for the live assessment once they have passed the SQE1 functioning legal knowledge assessment. So what that seemed to suggest is that actually performance in the SQE2 skills was mainly about an ability to understand and apply legal knowledge. So it was very much tied into candidates' legal knowledge. But of course, just to say that that is still to be viewed and interpreted with great care and great caution, given relatively small numbers. Now, just to remind us at this point, just moving back, if I may, for a moment to slide 9, the measures that we will be putting in place there on slide 9 in relation to quality assurance measures to make sure that the SQE is free from bias and is fair for all candidates will absolutely apply to SQE2 as well as SQE1. The functioning legal knowledge test, we can review the assessment questions, and we can make sure that the question writers are properly trained, including for unconscious bias, and that the questions are reviewed for cultural bias. In relation to SQE2, where the marking is human marking, then we must make sure that the assessment, the marking, the assessor decisions are very carefully monitored, and the question writer and the training happens both for writers and assessors for all skills assessments, naturally SQE1 and SQE2. So those mechanisms will apply both to SQE1 and SQE2. Now, final point to pick up on, because we're running already been running for half an hour, is about qualifying work experience. This is slide 21. So picking up there. Since 2016, through talking to stakeholders, some stakeholders have expressed concern to us that widening of the scope of qualifying work experience so that it includes working as a paralegal, working in a student law clinic, as well as traditional training contracts, could encourage less responsible employers to take on candidates without providing appropriate training, or in some sense to exploit them. So it could in some sense be exploitative. So that's the concern that has been raised with us. Turning to the next slide, it's important to recognise that we already have in place in our code of conduct a number of requirements which protect candidates from exploitation. There is a professional obligation on solicitors and on the entities that we regulate to supervise properly and to ensure that work that goes out through their front door is competent. We are publishing resources and have published resources in relation to qualifying work experience, which sets out our expectations about it, and which includes guidance, particularly with help from the Sutton Trust about unpaid work placements. So there is work there which is already on our website and will be further developed as we move forward. So interested in your views on that too. We do think that there is a great benefit to candidates through broadening qualifying work experience. We think it avoids the risk that we see at the moment of candidates getting stuck, even though they've passed all their exams, because they can't pick up a training contract. So we think that that is a benefit, but we're interested in your views on the on the extent of this risk and the range of the mitigations that we're putting in place around it. So finally, the questions that we'd like to hear back from you on are: do you agree that these are the right risks? Are there any risks that we haven't identified, and is there anything else that we could do to mitigate those risks? Our next steps, moving to the next slide, are that we are updating our EDI risk assessment. It says there it's to be published in May. It will be published today, so keep an eye out for that. It'll be published today, and we are also going to be launching a survey on that risk assessment. An email will be sent to you if you registered for this webinar. The survey link is in the YouTube description for the webinar, and the closing date is the 31st of May 2020. So a final reminder on our usual last slide about all the channels through which you can keep in touch with us. Please do keep in touch. Lots of work going on at the moment. We're very keen to hear from you. We're very keen in particular to hear your views on the draft updated risk assessment. Have we identified the risks? Are there benefits too that we haven't thought of that you can identify around all of this? Are there other risks that we should be aware of, or should we be less concerned about some of the risks that we've identified? So we're very keen to hear from you. Please do get involved. And just finally to say thank you very much for listening to this webinar. Very pleased that you spared the time to participate in this, and look forward to hearing your views on the risk assessment. Thank you very much indeed.